Number 35, the people of the state of New York versus William Wilkins. Let's just wait one moment, counsel, until they clear up. Counsel?
Good afternoon. May I reserve 2 minutes for rebuttal, please?
Yes, sir.
May it please the court, Dave Juergens, representing appellant William Wilkins. In this case, the trial court held 2 sidebar conferences with prospective jurors that dealt with their ability to remain impartial in this case. We know that Mr. Wilkins was not present, and we know that when they were held that he had not waived his personal fundamental right to be present. So we submit that Mr. Wilkins met his initial burden of establishing 2 Anamarchi violations, and the burden then shifts to the people to show that this record negates any possibility that Mr. Wilkins could have provided meaningful input.
Well, isn't that sort of begging the question? Because haven't we said that, and I realize that there are 2 separate questions. One is retroactive, one is prospective. But haven't we at least implicitly said that, and I think explicitly said as far as that you can waive, well, we've certainly said you can explicitly waive your right to be to be present at a sidebar, right? So we know that. It's a waivable right. The question is was it waived here? And can it be waived retroactively? Because here, the record shows that the defendant, in fact, did waive his right prospectively. Said, if I want to come and be at the conference, I'll let you know. So the question is under the circumstances here, where it was raised, the juror, at least one of the jurors, was still, in the box, subject to further questioning, and was questioned even after it was raised, and nothing was ever said. So, to me, the question is can we and should we recognize that as a permissible implied waiver? Not, whether, not necessarily. I mean, I think there may be a question as to whether he could have provided meaningful input, but I see that as really a very secondary question. So would you address the waiver issue?
Well, I think the waiver issue would go more to point 2 with respect to the prospective juror CO. The people...
CO or CK?
Well, let's do, on CK, basically the Anamarchi violations were brought to everyone's attention, and at that point there was options available to the trial court. The trial court could have...
Yeah, but didn't the court excuse her for cause? Or was that CO? CO, I think. CO, okay. Thank you.
Yes, with respect to juror CK, basically the trial court had the option of granting a mistrial or obtaining an express retroactive waiver of the fact that Mr. Wilkins was not present at the sidebar, or the court could have conducted a de novo conference with CK. None of those options were given to Mr. Wilkins. He was told about his right to be present on the record after the violation already occurred. And we look at what was said to see whether or not there was, I would argue there couldn't be an implicit waiver because we commonly think of an implicit waiver as someone being told of a known right, and then by their behavior they don't exercise that right. and we can see an
But
implicit
don't
waiver.
the implicit waiver cases come up in the context usually, I thought they came up this way, where they're told about the right, and then the issue comes up, and it comes up usually when a defendant is refusing to come to court, and the case law is developed out of that situation. There's an implicit waiver then.
And this court in People v. Flynn talked about an implicit waiver in this
Right.
type of situation where the defendant is told he's welcome to come up and attend the sidebar conferences, and then he doesn't do so. And from
One
that,
of the things I struggle with is saying, how can someone waive something that they don't know about? And here, the implicit waiver cases that I've seen are cases where there wasn't a waiver given, but there's a record before that shows a basis for that knowledge. I guess, is there anywhere in the record that we can look to? You're arguing there's a total absence of knowledge.
Yes.
Is there anywhere that you're saying that can be contested?
believe it was conceded basically by the parties in the court.
I had thought that the people pointed out to the judge that there was an error here.
Correct, and it was stated on the record that, yes, no Anamarchi rights were advised.
Is it really, or one way, let me put it differently, one way, apropos of what Judge Fahey is asking about, of thinking about this case and the factual scenario, is that it's not a waiver case, right? First of all, the comment about prospectively what he can do, he's clearly reserved his right. He hasn't waived any right, he's reserved his rights. And then the question becomes whether once he's informed of what he can do in the future, whether or not one would take his realization of the right to be present at the sidebars and not saying anything becomes an abandonment of the claim, the Antimarchy claim, with respect to the past violation, rather than seeing it as a waiver.
Well,
Can we look at it that way? Is that an appropriate sort of analytical framework for this case?
I don't believe I've come across any cases involving a forfeiture.
No, you're in the big times now. You're at the Court of Appeals, so the question is whether or not this might be one way of thinking about it.
Well, I think that
I mean, we do have case law that distinguishes, you've mentioned forfeiture from waiver, or whether or not in the context is an abandonment of a claim that exists, but that the person is not pursuing.
Well, Mr. Wilkins was never advised of what options he had. And
For
if he was,
the past violation, is that
for
what you
the
mean?
past violations. And there were no Anamarchi sidebars going forward. There were 3 sidebars that involved excusals for grounds that involved the jurors' availability to serve, not the jurors' impartiality. Here, the appellate division basically said that there was no Anamarchi violation because the co-defendant was acting as a second prosecutor, exercised a peremptory challenge, and therefore Mr. Wilkins never had any opportunity to give meaningful input to his attorney.
Do you agree with that analysis by the appellate division?
That was a misreading of the record. I believe Justice Curran in his dissent pointed out that the record fully supports the fact that they were operating under the mandatory statute, which says that co-defendants are to be treated as a single party. And in fact, the trial court would have no authority to direct the 2 co-defendants to operate independently. That would, as I've pointed out in my brief, would produce absurd results where it becomes important which defendant goes first during the exercise of the peremptory challenges. If you went first, you could exercise a monopoly over the perempts. If it was a split of the peremptory challenges, you could basically give an advantage to the second acting defense attorney. So I would, and then the absurd results part of it is that the co-defendant gets a reversal and Mr. Wilkins does not, simply because the co-defendant had a letter in the alphabet that was lower and went first, and I think that would be an absurd result.
Thank you, counsel. Counsel?
Good afternoon, Your Honors. May it please the Court, Scott Miles on behalf of the people. Your Honors, I believe this is a case where the waiver applies, the waiver of the right to be present at the sidebar conferences. Now, the record is clear that there was a waiver, an explicit waiver of all prospective sidebar
Oh,
conferences.
wait, let me stop you, sorry, over here.
Yes.
Let me stop you there. Do you perceive a difference between a defendant who says, I have complete faith in my counsel, I don't ever want to be at a sidebar? That seems to me to be a pretty clear waiver, and perhaps it can even be effective retroactively if it's stated that way, as opposed to a defendant who says, I'm going to take it on a case-by-case basis. If I want to come up each particular time, I'll let you know. That latter one doesn't sound to me like a waiver. It sounds more like a reservation of rights.
Your Honor, I don't believe there is any functional difference, because even in the case, the first instance of your hypothetical.
Well, I got to tell you, the chief would have a very different view if I said I am never going to dissent, and I said I'm going to take it on a case-by-case basis.
As I was saying, in the case of a defendant who says, I am never going to come up, to call that a waiver, whereas the other hypothetical is a reservation of rights, I believe is erroneous, because even in the first instance where a defendant says, I never want to come up, the defendants are always informed that they can change their mind at any time. So even that explicit waiver, blanket waiver, is revocable. So even that explicit blanket waiver is not an explicit blanket waiver, because the defendant still retains the right at any time.
So how can there be a retroactive implicit waiver that applies all the time? If it is as you say, you can change your mind at any time. Do something different whenever you want. So then how can we ever view something as an implicit waiver?
It can be viewed as an implicit waiver because the defendant never reasserts the right. In the case of Judge Wilson's hypothetical, a defendant who says, I never want to come up, and then remains seated, has not only explicitly waived that right through his words, but he has also implicitly continued to waive that right through his actions. So in any situation, even when there is an explicit verbal waiver, you kind of have to look
Is it possible to read the record that the judge is telling him, this is what you can do moving forward, and is not being informed about anything that has happened in the past, and that is all the defendant is responding to, as opposed to what you are suggesting that the defendant should have understood, the defendant himself, in that moment, should have understood, oh, this means I have to now say expressly that I wish I had been able to stand up before the court and be part of those sidebars that they're talking about.
Are we talking about the record as it exists in this case?
Yes.
I don't believe that's a fair reading of the record, because the trial judge, when he was reminded about the antimarchy violation, he points out that both defendants had remained seated during all previous sidebars, and asks the defendant if it's his intention to continue in that way. So the defendant was essentially.
But then if the defendant, as Judge Wilson's pointing out, then basically reserves the right moving forward, which means it is not a waiver, how can one view what happened in the past as a waiver? Right, he can't undo it, right?
No, you
Bell
can't.
has rung.
The bell had rung at that point as far as the jurors who had been excused. There would be remedies the court could have taken at that point with the other jurors who remained.
But he's not informed of that, right?
No, Your Honor, but it would be incumbent upon the defendant at that point to raise an objection, to say.
See, that's an odd analysis, because it seems to be that you're establishing a rule that in essence requires the defendant to preserve the objection to the process.
Your Honor, I believe.
I can't see any difference between the implied waiver analysis and a new preservation rule where there had never been one before that you're offering. There are circumstances where implied waiver has been properly allowed, but this is not that circumstance.
Your Honor, I believe the situation here is no different than the situation in People v. Spotford, where the court found that implied waivers, that a defendant's future actions can constitute an implied
Well,
waiver.
let me give you the language on spot where, first of all, that was held to be an express waiver. And there we said a valid implied waiver is whereas defendant is aware that the trial will proceed and failed to show up. That's certainly a situation, I think, where you're right. But that's not the situation we have here. It's a little different. Let me ask you this. I got 3 questions. First, would you agree that the court is the person responsible for informing the defendant of their antimarchy rights?
Yes.
Not his attorney, not the people, not the defendant himself, but the court must inform the defendant that they has this particular right, fundamental right to be present. That's what the case law seems to say. You agree with that?
Yes.
Second point is there any record support anywhere, and if you could just cite the pages where 270.25 sub 3 was violated, because I don't see you even asserting that it was violated in your brief. And the reason I ask is because the appellate division relied on that.
Yes, Your Honor. My difficulty with the appellate division's analysis is that the appellate division does not cite to the portion
Well, how
of the
about you?
record.
Do you cite anywhere that we could look to say it was, that this particular CPL clause was violated?
I do not, Your Honor.
So can we assume then that this was not violated and the people concede that point?
The people concede that I can't find it.
That's good enough. I trust you, because you got to know it better than all of us. So, all right. So my third point, that brings me to my third point then. Without, pre-knowledge of what, that the court supplied, it seems like we're saying that the defendant in this situation must bring this to the court's attention. The defendant must. And if he doesn't, that he hasn't preserved his right to challenge this.
I don't believe that is the situation, Your Honor. Because again, the defendant's antimarchy rights were explicitly explained to him by the court, just late. So at that point, when the defendant is informed of his rights, if the defendant does not assert that some remedial action be taken in regards to the sidebar conferences that he had not been present for before he was informed of his rights, if the defendant expresses no reservations or no issues with those conferences, then that combined with his express waiver going forward does constitute an implied waiver.
I do understand your argument, Mr. Miles, and let me say this. I respect your intellectual integrity for answering my questions the way that you did. Thank you.
Thank you, Your Honor.
Just to clarify what you just said, so you're saying that if the court never gave the defendant or notified the defendant of his antimarchy rights, then there's no obligation on the defendant's part to raise it.
Correct, Your Honor.
But once it's raised, the defendant may, by conduct or by inaction, indicate either whatever you want to say, a waiver or forfeiture or whatever, of those rights. And I'm not sure it even occurred to me, are you also sort of saying that by not requesting remedial action, that is actually a waiver going forward? That's a waiver of a right to request remedial action. Is that a separate right? I'm just asking the question.
I don't believe that would be a separate right. It would be the same rights as the defendant has under antimarchy to begin with. My point was that at the point that the defendant is informed of his antimarchy rights that have technically already been violated because there were sidebar conferences that took place without his presence before he was informed of that right. Once he is informed of that right, if he does not express any dissatisfaction with the process at that point, then that is an implied waiver.
So let me vary the facts slightly and ask what you think about this. Suppose immediately after the point where everybody knows there's been a violation and he's informed of his rights, there are no further sidebars. Is there still an implied waiver?
Yes, I believe, given the
So it
defendant...
doesn't really turn on the conduct.
I'm sorry, Your
It
Honor?
doesn't really turn on his failure to stand up and say, I want to attend this sidebar. Your argument isn't based on that at all.
Well, I think there is still conduct to look at in the fact that the defendant...
And that conduct, the other conduct would be sufficient, in your view,
I
to constitute a waiver?
Combined with his verbal waiver, yes.
Saying, I will let you know on a case-by-case basis and no other case shows up?
Yes, Your Honor.
Okay.
Thank you, counsel. Counsel?
Thank you.
What is the effect of defendant not raising the his absence from the prior conference after the judge instructs on the antimarchy rights? Is it your position that the defendant can just let that lay and?
Yeah, if the defendant is required to ask for some sort of remedy once he gains knowledge, that's basically the functional equivalent of injecting a preservation requirement into this analysis, which this court has said since 1992, a defendant is not required to object. It's a violation of his fundamental right to be present.
But counsel up here, sorry.
Yes.
Here's, I guess, a little variation on what this issue is we're batting around here. You're right on preservation, and I think what I struggle with here is, I tend to struggle with in some cases with motive proceedings errors and errors that don't require preservation. I can see the defendant's right to be present here, and let's say an ordinary case, defense lawyer goes up, defendant isn't present, defense lawyer knows the defendant isn't present, doesn't say anything, waits, gets a verdict doesn't like, transcript shows the defendant's not present. That's an antimarchy violation, and there was no need to preserve that error, and we've said that. Here it's different. And here, at a time when the error could have been cured, it's raised not by the defense lawyer or just with the defense lawyer, it's raised by the court with the defendant in the presence of his counsel when that juror is still available and nothing is said in terms of, I want the juror back, I want a mistrial, and we go on. Have a trial, get a verdict. That to me raises a fundamentally, if you want to say it as preservation, if you want to say it as implied waiver, it raises a fundamentally different issue. And I have so much trouble seeing why we would want a rule like that. Because it seems that entire justification of defendant's presence and the lack of any need for an objection is no longer there. Why would we want that rule?
I would say the rule should be that in these circumstances, defendant's got to be told what his options are by the court. The defendant's got to be told, and this is important here because this antimarchy discussion was sandwiched between two mistrial motions for instructional error, should have been given your options. Look, we got this violation. Do you want to just have a do-over? We'll grant a mistrial.
So the rule there would be, again, the defense lawyer has no obligation here. Even though in the defense lawyer's presence, the defendant is advised of this right. Presumably the defense lawyer knows what the remedies are. But again, we're going to say now the defendant has to be told that, and the defendant has to waive in some way specifically?
Well, the defendant...
Again, why would we want that rule?
The defendant should be given his available options if he chose not to exercise those options, saying, no, I'm good, don't have a mistrial, or no, I really don't need to have a de novo sidebar with the juror in question. then sure, the defendant, at that point, you might be looking at some sort of a forfeiture argument. But the defendant does not have a burden to cure the error. There was a clear Anamarchi violations. It could have been cured if there was a for cause challenge or if there was a...
Well, counsel, do we want to rule, since the court has made clear that the right is the defendant's, not counsel's, correct?
Correct.
Okay, so do we want to rule where a defense counsel may disagree with defendant about defendant's appearance at sidebar, and as a consequence, the lawyer conduct themselves in a way that suggests to this defendant that there is no right, or that the lawyer should be deciding that? Isn't the point that the court is interacting with the defendant? This is one of those rare occasions where the court is basically interacting with the defendant and saying the defendant has to speak as opposed to their lawyer?
Yes, I think this court has held essentially that it's a personal right of the defendant. Why we will, require a waiver to be in the defendant's presence, or if it's being reported by the trial court or by the defense attorney, this court has looked to whether the defense attorney has said, I've talked to my client, I've explained the rights to him, and he wants to waive the right in particular.
Well, it does kind of make sense that if the court is telling you what your right is, and the court has then failed in its duty, as Judge Fahey had already set out, that the court would explain to you what your rights are. I mean, isn't that the rule you'd want?
Yes.
Thank you, counsel.